purpose of the statute, the 1997 statute, was to make sure that the state was complying with the Internal Revenue Code. That's in the legislative history. I didn't see a whole lot of anything in the briefs about the Internal Revenue Code. Don't we have to look at that to see what the 1997 statute was trying to get at in order to figure out what it meant?
I'm not sure that edition in 1997 about the non-forfeitable right was strictly because of Internal Revenue Service regulations or federal tax law. Every time that the pension laws have been adjusted, including in that time, you are correct, but even in the 2010 law, and this 2011 law, challenge, they've always had to update our state law so it's in compliance with federal statutory law regarding pensions, so it remains a qualified pension plan. My understanding, Your Honor, is that Governor Christie Whitman at the time and the legislature provided a non-forfeitable right that is a contractual right to pensioners to receive their benefits. They weren't obligated to. There are many states where that's not the case. It might be a property interest. Mr. Lukey had submitted a 2611D letter regarding New Mexico. They don't have contractual protections for their pensioners. They have property rights. So they have some rights, but they don't rise to the level of contractual rights. In 1997, the state of New Jersey, for the first time in its history, and I use that language because that was from the state's brief at the time in the original NGA versus state case, provided a contractual right for pensioners to receive their benefits, and the benefits program wouldn't be reduced. I don't believe that right was placed there in compliance with federal law, although part of that original law did have adjustments to bring into compliance with the federal tax code. But that's also been the same with the 2010 amendments and the 2011 amendments that is subject to this appeal. So I don't think it's required, but the state provided it. And in fact, in this new law, Your Honor, in 2011, one of the things they did, allegedly for benefits reform, was the non-forfeitable right has been repealed for new employees as of the effective date of the law, June 28, 2011. If it were, as Your Honor suggested, a federal requirement, the state could not have repealed the non-forfeitable right going forward. So I don't believe it was a connection, but there certainly were adjustments made to the law to bring it into compliance with federal tax law.
I would also just like to note, again, I'm not going to go on to other areas, clearly the court is heard anything. I would just like to note that we recently found an Arizona case.
And you can provide us with that.
We've just found it. It's not.
We just found it. I think we're gonna ask for some additional briefing. Anyway, you can provide it. It's not fair to your adversary to sort of present it for the first time now.
I would only have cited it, Your Honor.
That's okay. All right. I think we understand your argument. We appreciate that. And we think we have heard sufficient argument to enable us to understand each side's position, and we are not going to hear another round of argument. However, we would like to give the parties the opportunity to specifically submit supplemental briefs directed to the question of the Internal Revenue Code and its significance or not with respect to how we are to interpret the 1997 statute. We will give the appellant's side 2 weeks to submit that brief. And at the same time, if you want to tell us about the Arizona case, that you can do that, even though it's not directly on with the IRC. But if there's something new you want to tell us, we want something short. If the appellants can possibly agree on to join each other in one brief, we'd appreciate it. If you can't, that's fine. 15 pages, no problem. And then the state will have 2 weeks to respond. We won't take any replies. If we want to hear anything else after that, we'll tell you. But 2 weeks from today, whatever that date is, for the appellant's brief, supplemental brief, and 2 weeks thereafter for the state's brief. Thank you all very much.